Good morning, good afternoon, and good evening. My name is Chiara Giorgetti, and I'm a professor of law at Richmond Law School. I'm the vice president of ABILA and the co-chair of the International Law Weekend. I'm really delighted today to welcome you to one really of the highlights of our meeting, the Friday keynote address. Though we cannot meet in person in the beautiful facility of Fordham University, I'm delighted that you can join us from wherever you are. As you know, the theme of the ILW this year is International Law in Challenging Times. And believe it or not, we chose this theme before COVID. But yes, we are living in challenging times. And in this meeting, we are exploring what role international law and us as international lawyers can play. And challenging bring always a lot of opportunities. And I have seen these opportunities being discussed in many of the meetings today and yesterday, including on different climate change, international environmental law, and of course, health. Now it is my pleasure to introduce our keynote speaker, Catherine Amirfar. Catherine is a partner at Debevoise & Plimpton, and she's a co-chair also of the Public International Law Group at Debevoise. Her practice focuses on public international law, international commercial and treaty arbitration, and international and complex commercial litigation. She's also a member of the firm's management committee. Prior to rejoining Debevoise in 2016, Catherine spent 2 years as counselor on international law to the legal advisor at the US Department of State. And during her tenure as counselor, she advised the State Department on its most significant litigation matters involving international law and foreign relations. And she represented the United States before many international bodies. In 2020, Catherine was appointed president of the American Society of International Law, and we're so glad for it. Among her many contributions to ASIL, she has co-hosted a podcast called International Law Behind the Headlines, which I highly recommend. She is ranked among the top international legal practitioners in the world by Chambers Global, and she has written extensively on international arbitration, the relationship between international law and US domestic law, international human rights and humanitarian law, investor-state disputes, and the law of consular and diplomatic immunities. She's a frequent lecturer on international law, and she guest lectured at many international and US law schools. Catherine is also a member of the American Law Institute, the Council of Foreign Relations, the State Department's Advisory Council on International Law, and the Court of Arbitration of the Singapore International Arbitration Center. She's been a long-standing supporter of ABILA. I'm particularly excited and pleased to welcome her for the keynote today. I've always admired her knowledge, determination, grace, and quick thinking. Her talk today is entitled The Making and Unmaking of International Rule of Law, and I very much look forward to it. She has kindly agreed to take questions at the end of her talk, and I would like to ask participants to please use the Q&A and chat function at the bottom of your screen. Many thanks, Catherine, for being here today, and over to you.
Chiara, thank you so much. It's really good to see you. Thank you for the kind words. My only regret is that I can't be in the same room with you and with our colleagues that's with us today. But here we are. So let me just start by thanking all of you for being here with me today. It's a privilege to address you, my colleagues, my friends. These are tumultuous times in which we can take nothing for granted. We come together in the midst of a pandemic, economic upheaval, and a mass movement against systemic racial injustice in our country and around the world. No one here needs any reminder that we are also on the eve of the 2020 presidential election, which some have called a battle for the soul of our country. It is a moment that I think is no exaggeration to say that we will look back upon as significant in the arc of our history. When I was asked to deliver this keynote, I knew that there was little else I could speak about other than the basics. And for lawyers, it is difficult to get more basic than the rule of law. As lawyers, we are keepers of a faith that unites us, regardless of our differences. All of us adhere to a central premise that law, not force, should rule the world. In April of this year, I was privileged to assume the presidency of the American Society of International Law, or ASIL. ASIL stands as a leading organization devoted to the study and promotion of international law in the United States and the world. This past June, the Society held its 114th annual meeting for the first time in virtual format on the promise of international law. At the opening of that remarkable event, I talked about ASIL's mission, and today I want to build on some of those same themes. I look at my topic today, the making and unmaking of the international rule of law, through the prism of the Society's mission from its earliest days over a century ago. ASIL was founded in 1906 with the express mandate, and I quote, to promote the establishment and maintenance of international relations on the basis of law and justice, end quote. From the very beginning, it was not a quiet mission, but was strident in its ambition, which was literally to change the world by contributing to a more just and peaceful society. The early leaders of the Society included 2 future Chief Justices and 3 Associate Justices of the Supreme Court, Secretaries of State and War, and William Howard Taft, who would become President of the United States in 1908. Elihu Root, a founder of the Society, wore many hats. He was the Society's first president and served as both the Secretary of War and Secretary of State. He wrote in the inaugural issue of the American Journal of International Law that one way to prevent war and other conflicts was, quote, to increase the general public knowledge of international rights and duties and to promote a popular habit of reading and thinking about international affairs. Lest anyone think he was being naive, he conceded that while the whole body of any people could not be expected to be familiar with international law, enough citizens could become sufficiently familiar with it to lead and form public opinion in every community in our country upon all important international questions as they arise. And so was born a society devoted not only to fostering knowledge of international law, but to translating that knowledge into action. ASIL stood witness to the lessons of history as humanity endured 2 horrific world wars, which fundamentally tested the premise of international law. While it is sometimes forgotten, many felt a profound sense of failure during the Second World War regarding the entire enterprise of international law and international institutions as a means of ensuring peace and stability. In 1940, Philip Jessup sought to refute the critics that were arguing that pre-war international law and institutions like the League and PCIJ had failed us. And in defending their prospects, observed that, and I quote his words, the bitter disillusionment of today is the result of exaggerated hope, not the ultimate collapse of human civilization. He went on to say that to believe in the imminent demise of international law was tantamount to embracing the counsel of despair. Now, as this group well knows, the reports of international law's death were greatly exaggerated. Far from meeting its demise, because of champions like Jessup, international law and institutions were given new life in a post-war world order, fueled by the belief in the power of the international rule of law and manifesting in the Dumbarton Oaks and San Francisco conferences. 850 delegates from 50 nations convened in San Francisco in June 1945, with almost 6,000 advisors, staff, media, and observers in attendance. The UN reports that the San Francisco conference was not only one of the most important in history, but perhaps the largest international gathering of states ever to take place. The last meeting, the San Francisco conference, was held in the Opera House on June 25th. Lord Halifax presided, and in putting the final draft of the UN Charter to the meeting, he said, "This issue upon which you're about to vote is as important as any we shall ever vote in our lifetime." The next day, the UN Charter and the Statute of the International Court of Justice were signed. As this group also well knows, the United States played a crucial role in this new world order, investing deeply in the architecture of the United Nations and the International Court of Justice. In addressing the delegates on the final day, President Truman stated, "The Charter of the United Nations, which you have just signed, is a solid structure upon which we can build a better world. History will honor you for it." Between the victory in Europe and the final victory in this most destructive of all wars, you have won a victory against war itself. With this charter, the world can begin to look forward to the time when all worthy human beings may be permitted to live decently as free people. Now, if you'll permit me to be reductionist for my purposes today, this long history can be said to embody the making of the post-war international rule of law, in that it established the foundations for the modern international system of laws and institutions. The story of the United States as a superpower in its relationship to international law and institutions has not been uncomplicated. Since the UN Charter, the US has fought an entrenched Cold War, approached the brink of nuclear annihilation, and participated in numerous armed conflicts, large and small. The international rule of law has been tested frequently. In the US as superpower era, there has been a strong pull in Capitol Hill and in the executive criticizing the international order. Invoking the rubric of US interests as paramount, as coming first, some have argued that international law is an anomaly and a myth propagated by weak states to prevent the strong from maximizing their power advantage. This is not a new theme, and we have heard its echoes recently, for example, in the context of the unsigning of the ICC Rome Statute by the George W. Bush administration. But even if not new, I think it is fair to say that this theme is now being played at a very loud volume. The Trump administration has either withdrawn or signaled its intention to withdraw the United States from the Open Skies Treaty, the World Health Organization, the Paris Agreement, the Intermediate Range Nuclear Forces Treaty, the Trans-Pacific Partnership, the Joint Comprehensive Plan of Action to Congress, and the Human Rights Council, and the New START Treaty has not been renewed. But it is more than just US disengagement from the international system. On September 3rd, 2020, the Trump administration issued an executive order formally designating and instituting asset freezes and visa restrictions targeted against prosecutors and investigators of the International Criminal Court. The US rejection of an ICC investigation into allegations of possible war crimes related to detainee abuse by US forces in Afghanistan is not new. This is a use of sanctions, however, not against war crime suspects, human rights violators, or corrupt leaders, but against international civil servants carrying out of their responsibilities to investigate war crimes. This action crosses a new line. It is naked aggression against the very fabric of the international system. As put by David Sheffer, ASIL's vice president and the first US ambassador at large for war crimes issues, this executive order will go down in history as a shameful act of fear and retreat from the rule of law. The long-standing alliances of the United States have not been immune. The Trump administration has called into question the 71-year-old military alliance NATO, leading some to speculate the announcement of withdrawal as an October surprise in the lead up to the imminent election. There's been deep criticism of the European Union, with President Trump most recently claiming it was formed in order to take advantage of the United States. Last quarter, President Trump announced the unilateral withdrawal of US troops from Germany without informing Germany of its decision. And throughout this administration, status of forces agreements have been the subject of both disparagement and disavowal. Around the world, democracies are under pressure. Freedom House reported that of the 41 countries consistently ranked free from 1985 to 2005, 22 have registered net declines in freedom over the last 5 years. Again, we see threads of this in our past. The 1930s economic pressures in the form of enormous debts, stagnant wages, chronic unemployment, and extreme inequality eroded or helped to erode the foundations of democracy and international cooperation, tilting popular support in some senses to faster them. Today, ultranationalists are ascendant across the democratic world, and increasing economic divides and income inequality may contribute to similar trends towards nationalism and extremism. So, what does this mean for the international rule of law? Are we at the moment of its unmaking? I make 3 observations with a view towards suggesting that while we may be at a crossroads, the unmaking is not upon us. First, one moment, whether comprising a day or a span of years, does not define the story of international law. It's been a long journey, and it is not over. One cannot look back on the vicissitudes of history and conclude that international relations are subject to inevitable progressive development towards peace and justice. Perhaps that is the hardest lesson. There will be forward progress and backward steps. Our traditions of civility and reasoned argument can be a poor match for a public discourse that has become ever more strident, divisive, and polarized. In some moments, it may feel that the country is no longer guided by the ideals that animated us as recently as the mid-20th century. But as I've just recounted in the story of the making of the international rule of law, this is not a new phenomenon. From its earliest days, the society and others have been swimming against strong currents of isolationism, parochialism, and militarism. Despite powerful forces arrayed in opposition to its vision, the society helped to mobilize sentiment to promote the ideal of a community of nations living peacefully under the rule of law. The 20th century severely tested this ideal with appalling conflicts and seismic shifts in global power, but our leaders did not abandon their effort to establish international relations on the basis of law and justice. Some might argue that the world is not much better off now than we were before the ascendance of the post-war international legal order. But the post-war order, even if imperfect, has fostered the most peaceful and prosperous period in human history, and its absence would make the world a more dangerous place. International law and institutions may not be able to perfect the world, but they are an indispensable instrument of progress. As Dag Hammarskjöld famously said, the United Nations was not created to bring us to heaven, but in order to save us from hell. His words resonate today. The international rule of law does not guarantee that everything will be all right, but it helps to prevent tyranny. It helps to protect the vulnerable. It helps to avert war. It helps us think about what is fair and helps us seek justice when confronting entrenched global problems like racism, climate change, corruption, mass migration, infectious disease, and armed conflict, just to name a few. Second, the backward steps do not constitute failure of the whole enterprise. Setbacks, even if painful, can prompt us to reassess our philosophies and strategies. Setbacks allow us to take a hard look at where international law institutions work better than others and adjust our sails as needed. So when the League of Nations proved too narrow and limited in powers to be up to the task of preventing another global war, the structure of the United Nations was conceived. When the massacres in Cambodia, the former Yugoslavia, and Rwanda took place, they gave new urgency to the idea of a permanent international criminal court, almost 45 years after the idea was first considered in the context of the Genocide Convention of 1948. When the reach of international law as ordering the relations between states proved inadequate, a different framework of human rights norms developed to reach state conduct, including vis-a-vis individuals within a state's borders. Whatever the adjustments made, our practical, clear-eyed vision of a better world remains undiminished. Third and finally, there are no historical inevitabilities, in my view, in the story of international law. History is replete with examples of how the work of individuals and institutions made the difference. The Paris Agreement was a remarkable example of international law being used to help solve a global problem. While serving in the Obama administration, I was struck by the regular efforts to ensure that US actions adhere to international law and the effort to build the rule of law around the world. Just as the United States led the world towards the rule of law in the past, a resurgent US focus on international law could have a beneficial impact throughout the world. In addition, each and every one of us has a role to play in defending the rule of law. And this includes effectively communicating a vision of the international rule of law to those not just within our circles, in our echo chamber. Some may not agree with all of the trappings of the liberal international order, but there is much upon which to agree. In the United States, for example, common ground can be found and is not determined by one's political party. The United States has long used treaties and international institutions, very often with a consensus between Democrats and Republicans, to project our values, our interests, and our influence. There exists a common understanding that a world that relies on a system of laws and shared norms is a safer and more secure world, and that we cannot expect other countries to live up to those norms if we do not do so. For example, some of the strongest allies in the critical work of the Obama administration in securing the fundamental protections enshrined in the Convention Against Torture came from our Republican colleagues and friends, including some in the armed forces, who agreed that the best way to protect our men and women on the battlefield was to make the legal rules protecting them ironclad. In 2017, when President Trump raised the prospect of relying on a torture program, 176 retired flag officers, including 33 four-star generals, wrote to him, pointing out that torture weakens US national security, is unlawful under domestic and international law, and violates our core values as a nation. They said, and I quote, "Our greatest strength is our commitment to the rule of law and to the principles embedded in our Constitution. Our servicemen and women need to know that our leaders do not condone torture or detainee abuse of any kind." Ultimately, President Trump did not announce a torture program. In short, one of the most important things we can do in our endeavors to contribute to a more peaceful world is to bridge the gaps between us and focus on ways to move forward, regardless of political affiliation. And so I end where I began, in paying respect to the critical work of our institutions. A century after its founding, ASIL is proudly bipartisan and stands for both established values and progressive ideals. The American branch of the International Law Association, since its founding in 1921, is part of a preeminent network involved in developing and restating international law. Our organizations draw from the very best of academia, government, the judiciary, private practice, international institutions, and civil society. Our organizations are invaluable in finding answers to the questions we face as a global community, and their potential for shaping the discourse is almost boundless. We may have always been swimming upstream, but we have come a long way already. I, for one, count us a formidable force in support of the international rule of law. I want to thank you so much for your kind attention. I'm very happy to answer any questions.
Many thanks, Catherine. This was a very rich and very thoughtful presentation. I think you really gave us, on one side, a realistic description of what's happening, but on the other side also kind of uplifting and saying, well, we do have a role to play. Individuals have a role to play. Societies have a role to play, the learned societies. And we have to look at the past. You know, we take 2 steps forwards and 1 step back, and that's fine. Because we have to learn. And so in these times of these challenging times, we can learn and use this as a pause button and say, okay, so what can we do? Where do we go from now? So now we are at this juncture. Where can we go from now? And I wonder if you can tell us maybe a little more about, so what do you think are the most urgent challenges on one side, but also the clearest opportunities? So where do we go from now? How do we take this and transform it into an opportunity?
Thank you, Chiara, and very well put. I think one of the dynamics that worries me most about the political discourse, not just in the United States, but globally, is the feel of the bitterness in the political divide. So much so that the idea of searching for common ground, the idea that Democrats and Republicans have a common enterprise, is sometimes dismissed with absolutely no pause, no sense that we can work our way back. And working with the Trump administration on certain issues, struggling to find that common ground, to me, is part and parcel to the development, the evolution, and the protection of the international rule of law. So I think one of the biggest challenges is in this moment of high emotion, of anxiety, of pressure. We are in a pressure cooker, not just in this country, but globally, that we can forget that reaching across the aisle to the person who may not agree on all issues, but we can get to common ground. History has shown us those are some of the moments in which we take leaps forward, in which we find our allies and we move towards a common goal, irrespective of the nomenclature, irrespective of political party affiliation, and just focusing on the basic core values. And I think history has taught us that. So now I think of that as one of our biggest challenges, is how do we get across to each other in this climate? And part of that, and some people have commented, we had our presidential debate last night. Some have commented that it was less about policy disagreements and more about disagreeing on basic facts, that there were these alternate realities that were being presented. And that, of course, presents a new challenge as well. It's not about necessarily different viewpoints, but the basis on which we're building is different, fundamentally different. And there's a chasm there. And we called them facts and the new normal. I won't even get into the nomenclature around it, but that there's something different about that. But that also requires, and it isn't all that different from what happened in the rise of fascism in Europe, not all that different. And the discussions in the United States about whether or not the US should intervene in the Second World War. This is a dynamic that is familiar. And just here today, my concern is that we are diligent about how we communicate the facts, but also diligent about reaching across the aisle. And it's so easy to do. It's so easy to say and so hard to do. But when you ask me what is the biggest challenge, I really think it's that. It's how do we bridge the divides?
Thank you very much. Very, very thoughtful again. I'd like to bring in one of the questions that we received. And the question is about what is the importance of third-party state interactions between disputes between two nations on a national scale. Working with a group dynamic of states can often be a difficult process, and from the standpoint of transitional justice or when acting an advisory role to one or several other nations in disputes, how can we better foster the cooperation without enabling a potential quid pro quo international favoritism between state actors and third-party advisors or cooperative states?
That's a really good question. Obviously, someone who's deeply in the weeds. And those themes are just so classic, right? It's the art of diplomacy. Mm-hmm. It's the fact that, and when I had the privilege of representing the United States on delegations, when we would travel as a delegation, so much of the art of diplomacy was about the strength of the existing relationships, the conversations that were had in the side rooms, and then bring it into the larger forum. And to me, I think that third-party state interactions, it gets very basic, right? It's about understanding where each state is coming from, having built that basis of trust enough to be able to withstand the disagreements and get to common ground. So for me, it goes back to the very basics of diplomacy. And if you hear Bill Burns talk about, and he's had this wonderful recent book issued about US diplomacy in particular, and obviously coming from a very, very experienced and respected diplomat, he speaks exactly to that question about how do you get these third-party states on an issue going in the same direction without being divisive. So to me, it just harkens back to the art of diplomacy, and it's one of the aspects of the international world order since the war that I think has been very undervalued of late, and is one of the primary goals for rebuilding that I think must occur, because it has been really undermined across the board for the United States, and building it back up will not be easy, but it is critically important that those communication channels get rebuilt, because that's the whole premise, right? Is to be able to use diplomacy in the pursuit of peace, to be very, very simple about it.
Thank you. Another question also from one of the participants. Well, first of all, thank you for the presentation. Catherine, you focus on the positive role that international law has played since World War II in discussing the international rule of law. In your view, in order for international law to be more valuable in addressing socioeconomic inequality around the world, which must increase, as you say, what can we do? So really very much what in your call for action, what can we do?
Well, I think that this is one of the issues that, for example, I have seen get a lot more traction of late through the prism of human rights. And it's thinking about the right to economic equality, the right to life, the right really to have a quality of life that then translates into ensuring kind of the other rights related to freedom of expression, whatever it may be. And I have seen that in the human rights movement, that economic aspect to it, social, economic, in the manifestation of more recent treaties, has really taken root. And I think in recalling that there was a really good study that looked at domestic constitutions in light of the international human rights movements, and found that that kind of right, the right to economic equality, and those rights that weren't core rights at the start of the human rights movement, but were developed, actually started manifesting in constitutions more often than not. And they had this pretty remarkable critical mass of constitution reflecting such kinds of economic related rights and social rights. So I think that the short answer to that is that it is a very difficult and entrenched problem, right? We are seeing economic inequality, racial inequality as these entrenched issues that haven't been addressed by domestic and international schemes to date in many ways. some ways that progress has been made, in many ways that hasn't. So it is part of that continuing struggle. I think what I'm saying is, with respect to international law, it gives us a construct, a legal scheme in which to look at these entrenched issues, think about basic fairness, think about how to balance these interests in a way that can get us to solutions. Because without it, we're just looking at entrenched problems, and every country trying to deal with it domestically isn't going to get us to where we need to be globally.
Mm-hmm. Thank you. This was, again, interesting and thoughtful. And there's another question, actually, that kind of follow is a little more general. And the question is, while most of us agree that the US disengagement has been unfortunate, what's your reaction to the claim that other countries have not really playing up their fair share?
And I wonder if that is picking up on one of the aspects of the America First platform that I have seen, and I've seen very recently President Trump invoke, is the idea that the international scheme or the international order is the United States footing the bill, taking responsibility, including financial, and third states freeloading. The idea that there's been this inequity in terms of the US experience in the international order that needs to be addressed and realigned to an America First ideology. And so as I said earlier, I do think that the fundamental premise of that is mistaken, in the sense of how much the US has benefited from the international order in terms of all of the treaties. It's too innumerable to name at this point. I will say that the ACIL has posted, and this is just on a very basic level, for example, the 100 ways in which international treaties have benefited and impact our lives. And some reaction to that was, well, that's too basic. You're talking about cell phones and credit card agreements right next to human trafficking. But in some ways, that's part of the point, is the idea that when we're looking at the international order, that we think of it as the US footing the bill and getting no benefit is manifestly, categorically in error. And how do we communicate that to individuals who haven't grown up in the international system, studying the international system, experts in international law? I think is a major challenge, and a reason why the America First platform got more traction, I think, than a lot of people expected, is because in ignoring how we talk about the benefits to the United States of the international order, there isn't a counterweight to the notion that the United States isn't benefiting, and as a superpower should ignore these rules.
Thank you. Yeah, I have to say that I always start my classes also telling the students how much international law shapes everyday's life. So I tell them, your computer, it's possible to have your computer in front of you because of international law and all the treaties and agreements that exist. So I agree. I think we have to let people understand more what the importance of international law, how it really shapes everyday's life. I agree with you that the idea of America First is really based on something that is not realistic, and it's very dangerous also. But we are in a moment where we are reshaping, right? So there is a rebalancing both of state powers. So the US is possibly even for the future, regardless of what happens on November 3rd, there is a rebalancing, and there's rebalancing that includes both states, but also institutions. Is the WHO gaining maybe possibly more importance? Do we want to reshape international institutions to look a little bit differently, maybe to look at the failures of the Security Council, the idea that the individuals and NGOs play a more and more important role. So I think we're really reshaping international law in many different ways. And I see a lot of questions about that. So in this reshaping of the world, what are we going to see? How do we rebalance both state powers, international organization powers, and who will be the most prominent champions in the international rule of law? And maybe it's going to be individuals because we are playing a much bigger role. But I wonder if you can say something about that. maybe mega question, I don't know.
Well, look, all of those examples you gave are some of the most trenchant examples. It's the idea of reform, right? And I think we have to be careful about our language, because I think at the same time that we must be in a position to adjust our sails as needed. And history is replete with examples of international law and institutions making those adjustments for the better. That reform, though, sometimes is used when they mean burn it all down. And so when I say reform, I'm saying it from the perspective of really adjusting the sails, looking at it from what is working, what is not working, not burning it all down. And so from that perspective, who can make a difference? I do think it's individuals. I do think, of course, you heard me. I think it's the individuals. I also think it's the organizations, the trusted voices. It's ABILA, it's ACIL. We have within our members an extraordinary amount of talent and in knowledge. And what we, if anything, if we suffer from anything, it's that we talk to each other too much rather than reaching out and speaking to the non-experts, speaking to the next generation about what this enterprise is and what it involves. So it comes down to how to make a difference. And I think it's as basic as that. And the other, of course, is in this moment of high emotion. If each of us thinks about our network and someone in our network we don't agree with on even some fundamental issues, is there common ground? Do we reach out on the basis of common ground? And in the presidency of ACIL, that's one of my priorities, is to try to make sure that we are reaching out not on the basis, and this is in honor of our bipartisan traditions, which I think are very, very important traditions in these critical moments, is to find our allies around the larger enterprise and find that common ground. So I think it's individuals, institutions, but also approaching it from that perspective is what I think is critical.
Thank you. I think we have time for one last question. And I'd like to bring in somehow a different perspective, and that is, but it links also with what we've just discussed. Both ACIL and ABILA are, the memberships are targeted. We have a lot of students. We have a lot of students in the audience now. And we are really international organizations. And we have several questions of really in practical, on a practical perspective, practically. One question, but I'd like to link it to others that I received. Being a young practitioner from a developing country, how can we expect to play a positive role in international rule of law, especially in these times where international law seems to be disregarded in favor of power and nationalism, given that the developing world has little margin or a lower voice to have an impact? What can lawyers, young practitioners, students, what can they do in practice? Of course, they can participate to these conferences, they become members of ABILA and ACIL. What in practice, what is your suggestion? What should they do?
Now, it's a very good question and so important, because it's the next generation, right, to carry on the traditions. It's so vital. Part of it is through professors like you, because you're imparting the traditions, the knowledge in a way that is going to engage another generation. The other, and you've already said it, is if you join an organization, for example, like ACIL, I have been struck time and time again when I talk to ACIL members, I say, where did you get your start? And these are preeminent academics, practitioners, members of NGO, members of the United Nations, members of governments. And they'll say something like, well, I was a young lawyer in X jurisdiction, and I joined ACIL. I worked in an interest group, and these are the things I started getting involved in. And then lo and behold, they were part of conversations, some of which took on the form of movements, others that led them to career opportunities, and they became professors themselves and practitioners themselves, and are in the leadership of our respective organizations. So to me, it really is about tapping into the international law and institution community, and using that as a base to think about these points of improvement, think about points of engagement, and then, and this is critical, go outside of that network. Mm-hmm. Be the individual who speaks to the international enterprise outside of this ILW, the ACEL annual meeting. Go to the tech meetings, the political science engagements, the meetings of governors, you know, go to these other places, but with that international enterprise in mind, and think about alliances and collaboration. And for me, you can't start too young. It's critical that young lawyers think about how they can do that in their respective countries.
Many thanks, Catherine. Unfortunately, our time is done, but I really thank you for this very thoughtful, very rich discussion, and really a call for action reaching on the other side of the aisle to everybody and participate. It is important. As individuals, we play a very important role. I'm sorry we are not in the big meeting, but thank you very much. I know that everybody is clapping with me.
Thank you.
Thank you very much. It's wonderful to have you. For the participants to the ILW, we now have a short break, but please join us for networking rooms at 1. This is a very important moment also for us to be able to connect with other participants at the ILW. We still have a day and a half of very rich and interesting programs tonight. We have a trivia on international law, many opportunities to know each other, very important panels, and tomorrow also a panel celebrating the 75th anniversary of the United Nations. So thank you very much, Catherine. Thank you for everybody for participating at this very important meeting. And I hope to continue to see you for the remaining of the ILW. Thanks again.
Thank you very much, Chiara. Great to see you.
Thanks, great to see you.